Honorable members of the bench, may it please the court. I, Mohammad Hassan Farhan, am today presenting my case. Mohammad Hassan Farhan. Yes. Your Excellencies, today the prosecution stands before the International Criminal Court in the case prosecutor against Mohammad Nizam. As the first speaker of prosecution, I shall be arguing on the issue of genocide, whereas the second speaker will be adhering to the issues of Article 7 of the Rome Statute under crimes against humanity, displacement, and murder. Your Excellency, before I begin my set of pleadings, would the bench care for the summary of facts? Much obliged. Your Excellency, this case is set in the Republic of Ashkar, where post-elections chaos unfolded carried out by the Biranis. Therefore, as a result, the government, led by Mr. Mohammad Nizam, ended up carrying out certain heinous acts and egregious acts that resulted in crimes of charges such as genocide and murder being placed on him. Therefore, today, in court we stand representing the prosecutor, and on trial is the defense, Mr. Mohammad Nizam. The prosecution submits that Mohammad Nizam, during the period of November 2023 to September 2024, is criminally responsible for the crime of genocide under Article 6A to C of the Rome Statute. The evidence before this chamber establishes that first, that the Biranis constituted a protected ethnical group. Second, that genocidal acts were committed against them. Third, these acts were carried out with the requisite dolus specialis, which is the special intent. And finally, that Mohammad Nizam bears individual criminal responsibility under Article 28B as a civilian superior. Your Excellency, before I begin my first line of pleadings, what I would like to state out is the statute of Article 6, which states, for this purpose of this statute, genocide means any of the following acts committed with intent to destroy, in whole or in part, a national, racial, religious, or ethnical group, Your Excellencies. The clauses of this statute state killing members of a group, causing serious bodily or mental harm to the members of a group, and deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. Your Excellencies, the first line of action by the prosecution is to establish that whether the Biranis were an ethnical group or not. And in our case, they did belong to an ethnical group. The evidence for this is in the statement of agreed facts, which establishes in paragraph 7 that the Biranis comprised approximately of 22% of Ashkar's population, formed identifiable ethnic enclaves, and were socially and politically recognized as a distinct community. Their presence in areas such as Zuldir was not incidental, but reflected a shared ethnic identity rooted in common linguistic, cultural, and historical traditions. Your Excellency, this legal test was well settled in Prosecutor against Akaizu, paragraph 511 till 515. No, Your Excellency, but there has been a history of them being a minority. Yes, Your Excellency. However, to further assist you regarding that, the reason there was no prior history of that was because the government was always formed by the Khalgaris. Right now, this time around, Biranis, despite being a minority, formed the majority of the government. These were worrying signs for the majority of this state, which is why after this, they carried out such crimes. If that satisfies the bench, may I proceed with that? Much obliged, Your Excellency. It is well settled and no longer contested that the ethnicity of the Biranis belonged to that of a protected group under Article 6. Therefore, now we must establish all three material limbs of genocide. Your Excellencies, Article 6 criminalizes the killing of members of a protected group. Paragraph 37, as may I direct you, the Statement of Agreed Facts records a death toll of 189,762 individuals, overwhelmingly Birani civilians. These deaths result from state-directed military operations, Your Excellencies, and these were directed as a precision elimination missions. However, in reality, these were employed unguided munitions, including napalm. Your Excellency, you may wonder why I have mentioned the use of napalm. To direct your attention, I would like you to please be directed by please be handed over by my researcher a copy of Convention on Prohibitions or Restrictions on the Use of Certain Conventional Weapons, which is the treaty that Ashkar is a signatory to. Your Excellency, over here on the first page, it says incendiary weapon means any weapon or munition which is primarily designed to set fire to objects or to cause burn injury to persons through the action of flame, heat, or combination thereof produced by a chemical reaction of substance delivered on the target. Your Excellency, over here, the Statement of Facts documents a use of napalm canisters, which in itself is recognized by Ashkar to be an illegal weapon as well, as it causes burns and ended up burning 5,601 civilians in an attack by Mohammad Nizam on these civilians. Your Excellency.
Has this been contested?
Yes, Your Excellency. In paragraph 51 of the agreed statement of facts, as I may direct your attention, yes, Your Excellency, paragraph 51. Second point. It says 17th August 2024, 3:40 a.m., town caliber weapon 12 napalm canisters and deaths 5,601, Your Excellencies, out of which many were burned alive. Your Excellency, if that satisfies the bench, may I proceed with my arguments? Much obliged. Your Excellency, moving on from Article 6A, we move towards Article 6B, which is causing serious bodily or mental harm. We have already established that napalm canisters were used to burn these civilians. Furthermore, between November and December 2023, systematic raids by the state on the basis of unverified intelligence, as quoted in paragraph 55 of Statement of Facts, show that 180,000 Biranis were forcibly displaced into military camps, subjected to routine interrogations and family separations, as well as constant surveillance, Your Excellencies. As recognized in the case of Uganda, beatings, threats, and terrorizing environments constitute serious mental harm. Furthermore, scholarly authority which has been relied on in constant ICC cases and written by Nagore Orziola Bastida confirm that sustained psychological breaking of a group satisfies Article 6B. Your Excellency, we move towards the last limb of the actus reus of genocide, which is Article 6C, which is regarding the conduct of the perpetrator. On 7 July 2024, Birani towns were encircled. As paragraph 50 states of the Statement of Facts, electricity and water were cut off and road access was blocked. This siege alone resulted in 31,000 deaths, many due directly to lack of medical care. Your Excellency, Birani districts were ordered to be cleansed. Homes were destroyed, wells were poisoned, and 480,000 civilians were confined to containment zones with grossly inadequate resources. In the cases of Kaishima and Rizindana, paragraph 115 and 116, the ICTR recognized that rendering survival impossible through displacement and deprivation constitutes genocide. Is the Honorable Bench with me? Much obliged, Your Excellency. Your Excellency, after establishing the actus reus through proving these three material limbs of genocide according to the statute, the Rome Statute, we now move towards the third limb of our argument, which is proving dolus specialis, aka genocidal intent. Your Excellency, genocide is distinguished by its unique mental element, the intent to destroy a protected group in whole or in part. Direct evidence of such intent is extremely rare. However, international jurisprudence constantly allows intent to be inferred from circumstantial evidence. In the case of Akaizu, paragraph 317 of Bosnia versus Serbia, the ICTR held that intent may be inferred from general context, the scale of atrocities, and the systematic targeting of victims. Your Excellency, here the pattern is unmistakable. Mass killings, repeated targeting of Birani heartlands, direct destruction of Birani districts in which 320 villages were rendered impossible to go back to, as agreed upon in the statement of facts as well, in paragraph 55 and 56. Your Excellency, this reasoning that the Birani heartland of Marra was precisely such a part and why intent suffices was reaffirmed in the case of Karachi, where the permanent removal of a group from a specific area supported genocidal intent. Your Excellency, proving the genocidal intent, and if the bench may have no clarifications, I would like to move towards the last limb of my argument. Your Excellency, to answer your question, Mir Raza was a very charismatic leader who was in Ashkar, and this has been confirmed in the statement, agreed statement of facts. As he was this kind of leader, he had a lot of sway over people as well as the majority. Your Excellency, to answer your question, there is this misclarification over here that the voters, the BLL was a political party. Yes, Your Excellency.
Parties are more popular among certain ethnic groups. Yes. That's phenomenon we see throughout the world. Was the BLL more particular, did it receive more support within certain provincial areas or by a certain ethnic group?
No, Your Excellency, they were receiving votes from throughout the Ashkar, so throughout different people. Your Excellency, they were popular in areas of Zuldir, Marra, and other areas where primary population was of Biranis.
So now, if the political party had more support from Biranis, and if the government decides to act against individuals who are creating unrest within the state, and if those individuals predominantly belong to a certain ethnic group, are they on the basis of the government perceiving them as a threat? Now, we're not condoning the use of force against civilians. That may or may not be wrong. But when you say that the purpose of eliminating them was genocide or ethnic bias, we want to understand whether the government was in fact motivated by ethnic bias, or was the government motivated by the fact that it perceived members of a political party to be acting against the state, and as a result, it was acting against individuals of that political party only. Because right now, we're not discussing whether the government's conduct was right or wrong in the abstract. Yes, we're discussing whether this conduct amounted to genocide or not. So, an important element for you is to show us that the government was solely and only motivated by a desire to eliminate a protected group.
Your Excellency, to answer that question, there are two distinct ideas over here. First is that yes, as a response of the chaos ensured by the Biranis at the death of their leader, the government did state that there was as a response. However, even the death of Mir Raza was contested to be mysterious as he died just after.
That's not the question before us right now. The only question that we're determining right now, as the International Court of Justice, is whether the government's conduct amounted to genocide or not. Now, earlier, your argument was predicated on the assumption that, well, the government now hates an ethnic minority, an ethnic group, because they have suddenly occupied parliamentary majority. Nonetheless, we see that while the elections were in October, there was no reaction from the government until November. So the triggering point for us seems to be the unrest that was created by members of a political party. Now, the government's conduct may well be illegal. Right now, our question is more narrow. We are only concerned with whether or not this amounted to genocide. For that, you have to show that the government was completely driven by vengeance and a desire to eliminate this protected group, not by a desire to protect. Now, the government may well be insecure, it may well have transgressed all boundaries in trying to quell what it viewed as a threat to the state. But you have to show us that there was some reason that the government was purely driven by their hatred towards the Biranis. Because your argument is that the Biranis are a political group, are a protected group. You're not saying that the members of BLL were a protected group. So if the argument is that the Biranis were a protected group, Your argument needs to be that the government was moved by a vengeance towards the Birani.
So, Your Excellency, just for my clarification, what you're trying to ask is for a fact from this statement of facts that shows that the government had hatred, internal hatred towards the Biranis.
The Birani, not the
Yes, yes, the Biranis. Yes, yes, the Biranis. So, may I just take a moment to refute my statement of facts?
Kind of.
Yes, Your Excellency. Your Excellency, may I direct your attention to the statement of facts, paragraph number 57, leaked ministerial statement of facts. 57. Your Excellency, now that I may have your attention, it states the Birani problem must be resolved conclusively. If the separatist sentiment is rooted in their communities, then those communities must be broken entirely. Yes. Yes, Excellency. But to further on in this very paragraph. No, Your Excellency. In this paragraph later as well, it says make Mara uninhabitable for those who defy. We cannot allow people who reject the state to survive within it. Remove them from the land if necessary. Yes, Your Excellency. Further on, in paragraph number 59, on defy Ashkar's unity. Your Excellency, may I refer with my research? Your Excellency.
And like I said earlier, we may well agree with you that the state's conduct over here is questionable. We only want to understand, because if we pass the decision today, we don't want any political group who's being oppressed in their own countries to come to the ICJ and argue that there is genocide. Because we cannot expand the contours of genocide to include every human rights violation, right?
Your Excellency, the prosecution understands the gravity of genocide itself and how grave it is the largest degree of international crime, international law. However, over here we do condemn as a genocide because not just because of the number, but because of their deep-rooted sentiments. To again direct your attention, I would please like to have your attention towards the agreed statement of facts, paragraph number 58, which states Birani districts must be emptied for security filtration. Civilians who refuse relocation are to be marked as hostile. Movement will be restricted until each zone is cleansed of Birani presence. Your Excellency, over here, this is very evident that they were even targeting civilians who were just refusing relocation. Your Excellency, if a civilian has spent their entire life in a certain home, spent all their savings, should the government not have some level of empathy towards them? Instead, they are calling them as hostile and militants and terrorists. So the government does not have any set boundaries to establish who is a terrorist and who is not. Furthermore, Your Excellency, towards, if I may redirect your attention to the statement of facts earlier, it states in paragraph 52, page number 11. Over here, the military stated that the intercepted communication suggested Hassan-aligned militant regrouping, though later investigations found no such evidence. Then, Your Excellencies, in paragraph number 48, it states, the villagers recounted that soldiers fired indiscriminately into homes after receiving intelligence report of hidden weapon caches. The ANA recorded 98 firefights, but aerial and satellite imagery later revealed only 19 actual military encampments. Casualty in this phase amounted to 57,320 deaths. The final phase resulted in the highest loss of life. Your Excellency, the government and Mr. Nizam need not say, even though he has said that he has been stating ways to cleanse the Birani population, but his actions as well show that he was relying on unverified intel and hastily acting without recklessly acting towards Biranis, which shows that he had zero empathy for these people. If a leader does not have empathy for a certain sect of people, that means he does not care how many losses occur. And he himself has also stated in statement of facts that losses of Biranis are just collateral damage. That is all from the prosecution counsel, prosecution counsel, Your Excellencies. To conclude my arguments, may I present the liability of Mohammad Nizam under Article 28B as a superior responsible person. Much obliged, Your Excellency. Your Excellency, the prosecution finally submits that Mohammad Nizam bears individual criminal responsibility under Article 28B as a civilian superior. First, he exercised effective authority and control. In paragraph 57, the ministerial directive ordering Marrah to be made uninhabitable, oversight of evacuations, and authorization of containment zones demonstrate such control. Then, second, Nizam knew or consciously disregarded information clearly indicating the commission of crimes. And third, he failed to take necessary and reasonable measures. This includes issuing counter order measures or initiating investigations. However, Nizam, on the other hand, was disallowing investigations. There has been countless mention of in the statement of facts where Nizam has disregarded any kind of independent investigations taking place. Your Excellencies, the prosecution in conclusion submits that all legal elements of genocide under Article 6A to C have been met, the genocidal intent has been established beyond any reasonable doubt, and that Mohammad Nizam is individually criminally responsible under Article 28B for failing to prevent or repress these crimes. Your Excellency, ignorance of law is no excuse. Mohammad Nizam over here has acted recklessly towards his own people, or as they should have been his own people. The prosecution submits that such an unempathetic leader and such a heinous crime committing leader must be charged with the crime of genocide. That is all, Your Excellencies.
Honorable members of the bench, may it please the court. My name is Myra Khan. I'm the junior counsel representing the prosecution side in the case the prosecutor versus Mohammad Nizam. I will be Myra Khan. Myra Khan. I will be speaking for a total of 12 minutes in which I will cover issue number 2, 3 along with my prayers. If I have your kind permission, may I begin? The Honorable Bench, Count 2 is a forced displacement which comes under Article 7(1)(d). There are 5 elements to prove Article 7(1)(d). First, the act is serious, deportation or forcible transfer of civilians. Second, the victims were lawfully present. Third, the lack of grounds permitted under international law. Fourth, the contextual element, which says that conduct must be widespread or systematic, directed against the civilian population. And finally, the mens rea. The perpetrator must know that the conduct was part of a widespread or systematic attack directed against civilians, and there is no requirement to prove genocidal intent. Knowledge is sufficient. Your Excellency, I will now move on to establish the actus reus of the crime. Your Excellency, Article 7(1)(d) criminalizes deportation or forcible transfer of population where civilians are compelled to leave an area in which they are lawfully present in. Your Excellency, under international law, it says that displacement forms part of a widespread or systematic attack directed against a civilian population. The jurisprudence is settled that forcible displacement does not require physical force as held in prosecutor versus static. The tribunal held that forcible transfer encompasses displacement caused by threats, fear of violence, detention, psychological pressure, or the creation of circumstances that leave no real choice but to flee. Your Excellency.
The third element that you referred to is lack of grounds under international law. Now, your colleague has informed us that there has been displacement. The fact that there has been displacement is uncontested. What we really want to know is under what grounds would the state be justified in asking its citizens to relocate. So, for example, we have seen incidents in countries like Pakistan where while dealing with militancy and terrorism, they've asked entire civilian populations to leave a certain village so that they can eventually carry out operations in those villages and avoid human uh, deaths of people who are not involved in conflict. Now, that is a situation which apparently suggests that there might be certain situations where civilians may be asked to leave. So, could you identify the grounds under international law where a state may in fact ask its citizens to leave, even if they were lawfully present in the area?
Much obliged, Your Excellency. Your Excellency, Article 17 of the Additional Protocol 2 permits that displacement only where imperative military necessity or civilian security demands, but even then on a temporary basis with adequate safeguards, none of these conditions were met over here. If I have satisfied the bench in this regard, may I move on to my arguments?
You haven't.
Could you confirm if the Birani military presence was embedded in the civilian population, or were they geographically distinct?
Could you please repeat your question again?
So the Birani military encampments and the military insurgents, the people who held these separatist sentiments, did they operate from different locale, or were they embedded in the Birani civilian population?
Much obliged, Your Excellency. The insurgents were operating from different areas and they were also embedded within the civilians.
And based on that, can you explain how this isn't just military objectives to sort of weed out the military insurgency that's causing unrest in the state? How it's not a legitimate state objective to try and ensure safety for the civilians by taking out and targeting the military insurgents, like you said, that are embedded in the civilian population?
Much obliged, Your Excellency. Your Excellency, the answer to your question is further in my arguments. So if Your Excellency wants, I can address it now or later.
You can, yeah, I'd prefer it now.
Okay. Your Excellency, the displacement of the Birani population was neither temporary or protective. Sieges, airstrikes, and destruction of
That was asked was slightly different. We would like you to address us as to what constitutes temporary, what is permanent, because you said that it has to be temporary and adequate protections have to be given. But the question that was raised by the bench earlier was that were they embedded in the population? You said they were. Now, was the displacement then not a valid, legitimate military objective? That is the question that's asked. So,
Your Excellency, I would like you to direct to the agreed statement of the facts, page number 12, paragraph number 56. Line number 5. If the bench allows, I would like to read it aloud. Witness testimonies allege that soldiers used loudspeakers to direct Vidani families towards designated protection zones, which were in reality zones of containment where movement was restricted and food supplies rationed. And satellite imagery later revealed that over 320 Birani villages were partly or fully destroyed during these months, primarily engineering units. The destruction of homes, agricultural land, and critical infrastructure rendered return impossible, effectively transforming short-term displacement into a permanent uprooting. Your Excellency, this paragraph clearly states that the evacuation was not temporary, but it became permanent because the state bombed 320 villages of the Birani civilians, and they
How long does the relocation have to be when it moves being temporary to being permanent? Can you refer us to a case where any international tribunal court has dilated on what is temporary relocation, what is permanent? I'm assuming we also need to have a flexible definition because temporary or permanent also depends on the nature of a conflict. If a conflict lasts 10 years, then it would perhaps be unfair to give a state a certain time period, right? So we've seen, for example, the refugees from Afghanistan migrate to different countries for 20, 30 years because the country has been in a state of constant conflict. So can you refer us to any decision by any tribunal, this court, where we have dilated as to how long can relocation be?
Your Excellency, Prosecutor versus Nidkanda, ICC Trial Chamber, it is the clarifying that displacement is forcible if it results from a coercive environment and highlighting that the destruction of property can contribute to the environment.
The question is, how long does a relocation have to be for it to be permanent? Now, if you don't have any case law, perhaps you could try to hazard a definition yourself. This court can then see if it agrees with your definition or not. But is there any decision by any forum which has dilated on how long does a relocation have to be for it to maintain its temporary character?
Your Excellency, according to the facts of the case, which says that the short-term displacement was turned into a permanent uprooting.
Our question, and I repeat it third time, is there any judgment, any order, any decision rendered by any forum which has dilated? Because we're asking not about the facts, about the law right now. We'll then apply the law to the facts. But our question is very simple. Has there been any decision where the court has dilated on how long does a relocation have to be for it to be temporary? At what point would a court say that, well, now this has moved beyond being temporary and now this is actually a permanent relocation? So yes, is there any decision? Yes, no. Let's hear the yes and no first and then we can talk about this further. Is there not?
Unfortunately, Your Excellency, I cannot assist the court in this regard.
In this respect, now we're asking you a question. In your opinion, how long should that period be? If this court today passes a judgment saying that, well, this is how long you can actually relocate somebody, after this it becomes permanent, how long should that period be?
Your Excellency, the state's operation was conducted in 3 parts over the period of 10 months, and the Birani civilians were told to evacuate. However, they were put into many died. 31,000 civilians died in that
Counsel.
protection zone.
Counsel, take a deep breath, listen to the question, and then answer the question which is asked. Our question is, if you had to give a legal definition, if you wanted us to set a certain standard, what standard should we set? How long is a relocation temporary? When does it become permanent? 6 months, 1 year, 2 years, 3 years, 5 years, 10 years? That is the question. Because you don't have any judgment where this court has said the same, so we can't apply a standard that has been set by a certain decision. So we're asking you to set a certain standard or recommend a certain standard. We may agree with the standard that you propose, we may disagree with it. But what, in your opinion, should that standard be?
Your Excellency, in my opinion, that standard should be 6 months, but the civilians should have a
That's
home
fine.
to go back to.
We understand that. Now, let's say there's a military operation in an area that lasts 6 months. By the time that military operation concludes, properties are completely ransacked, properties are bulldozed. Now, we perhaps agree with you that citizens should have a home to go to, right? Let's say the military operation concludes in 6 months. The state perhaps would, in all fairness, require 6 months to a year to rebuild those homes, rebuild roads, schools, hospitals, infrastructure. So that brings it about to a year and a half, right? When were these people displaced?
Your Excellency, during the second phase of the
Which was when?
Operation Iron Harvest during February
Which year?
2024.
So it's been exactly a year and a half since they were displaced. Thank you, Council. Proceed.
Your Excellency, this case is not about population movement in a conflict zone. It is about how the state used law, force, and deprivation as instruments of expulsion to erase the civilian population from its homeland. Your Excellency, to establish the accuracy of forcible displacement, the prosecution submits that approximately 480,000 Birani civilians, nearly one-third of Mara's populations, were subjected to forcible transfer within the meaning of Mara. Your Excellency, this is the textbook coercion. Your Excellency, can I have a minute to conclude my arguments? Thank you, much obliged. Your Excellency, this is the textbook coercion as understood in Static and reaffirmed in Prosecutor versus Popovic, where intimidation combined with state authority did not leave any genuine choice. Your Excellency, coercion was further intensified through systematic deprivation. I would like you to move on to page number 11, paragraph number 49. Your Excellency, the people were faced with the choice between fleeing or death, detention or starvation, civilians, and they were bombardment, and those bombardment weren't incidental. It functioned as a primary tool of displacement and terror. This satisfies the accuracy of forcible transfer. Your Excellency, furthermore, the Birani civilians were lawfully present in areas from which they were displaced from. Your Excellency, finally, I will prove the mental element of the crime, which is the mens rea. Your Excellency, the ministerial directives proves that the accused had actual knowledge of the criminal consequences of these operations, despite being informed of significant civilian casualties. Your Excellency, I would now like to move on to my prayer. The Honorable Bench, in the light of the evidence presented in the statement of agreed facts and legal authorities cited, the prosecution respectfully submits that the pre-trial chamber to confirm all charges against Mohammad Nizam, finding that there are substantial grounds to believe that he is individually criminally responsible for the crime of genocide under Article 6A, B and C of the Rome Statute, the crime against humanity of enforced displacement under Article 7(1)D, the crime against humanity of murder under Article 7(1)A, and the superior responsibility under Article 28B.
Mr. President, Your Excellencies, and may it please the Court. My name is Aisha Bukhari, and my team code is OST
Ms.
13.
President, but
My apologies. Ms. President, Your Excellencies, and may it please the Court. My name is Aisha Bukhari, and I am from team OST 13D. Together with my co-counsel, Ayan, I represent the defense. Your Excellencies, for the next 8 minutes, I shall be addressing count 1, whereas my co-counsel will be addressing count 2 and count 3. We shall reserve 2 minutes for sir rebuttals. Your Excellencies, I shall be dividing my submission into 2 parts. First, that the attacks perpetrated against the Birani protected group do not commit genocide. And second, that the physical elements of genocide are not established. And Mr. Nizam, as a Prime Minister, cannot be held responsible as a civilian superior under Article 28B of the Rome Statute. Your Excellencies, as regards the first submission, that is the constitution of the crime of genocide, we have three submissions. First, that the attacks were not targeted at a protected group. Second, the physical elements under Article 6 of the Rome Statute have not been established. And third, there is no evidence of genocidal intent in the present case. I shall be addressing each of these elements in turn. As regards the first element, Your Excellencies, it is required under Article 6 of the Rome Statute that for a protected group, which I would like to submit to the court, Article 6 stipulates that for a protected group, it must be a national, ethical, religious, or a racial group. This definition of genocide is strict, and therefore, in the present case, we rely on the ICTR case of Nahinama in paragraph 496, which states, for a conviction for genocide, the victim of a protected group must be targeted for the reason of belonging to that group. Your Excellencies, in the present case, here, there is no proof that the prosecution could establish that the targeted group in the present case was targeted for the reason of their ethnicity, rather than the fact that there was a political instability region in the state of Ashgar.
Councillor, we're aware of the fact that despite winning a parliamentary majority, the Biranis only comprised 22% of your population, which means that their supporters must have come from other ethnic groups as well. And the Biranis must only be a small portion of the people who support them, vote for them. Despite that, we see that the victims of your state's violence were predominantly Biranis. Is there any justification for that?
Your Excellency, the target groups that were launched by the state were not against Biranis, but rather they were against the areas that were from where the insurgencies were launching from.
Now, could we invite your attention to paragraph number 57 of the agreed facts?
Certainly, Your Excellency. Yes.
Could you read that out for us?
Precisely. The Birani problem must be resolved conclusively.
Now, let's stop here. Must be resolved conclusively. Can you historically tell us where these words are inspired from, taken from?
Your Excellency, in this scenario, these statements of the Birani problem being resolved separately is from a ministerial directive.
Because right now, there is no other way for us to gauge the intentions of your state other than look at these ministerial directives, right? So this ministerial directive shows two things. One, it shows a severe prejudice against Biranis. Now, like we said, that supporters of the BLL came from a number of other ethnic groups as well. Nonetheless, we see that all such communications exclusively talk about the Biranis, which shows that the state was also predisposed towards treating the Biranis as enemy aliens. We're also aware of the fact that such language was used by proponents of Nazi Germany, that the Jew problem must be resolved conclusively. So when you say something like this, that the Birani problem must be resolved conclusively, it, to our mind, shows or demonstrates your predisposition towards acting towards the Biranis. Because it does not say that, well, those who are acting against the state must be rooted out, or those who are taking the law into their own hands must be proceeded against. It specifically targets the Biranis, which is the prosecution's case. So how do you justify communication like this?
Your Excellencies, I shall respond to your question in two parts. Firstly, the directive that has been leaked is not a statement of the Prime Minister, which is the client that I am representing. Second, the fact that we would like to distinguish this present case.
No, because your argument rests on two prongs. The first prong is that there was no genocide. The
Yes.
second prong is that, well, it is not attributable to the Prime Minister. So
Yes.
either you say that, well, there may have been genocide, but that genocide is not attributable to the Prime Minister, and you
Certainly.
withdraw your first submission. If you want to make your first submission where you're saying that, well, there was no genocide, then you have to defend directives like these because they are attributable to your state, even if not the Prime Minister directly.
Precisely, Your Excellency. In response to that, the genocide not being committed in this present scenario, we would like to distinguish the case from the case that Your Excellency himself relied on. That is the case against the Jews by Hitler himself. also from the ICTR case in Nahinama, which is very similar to the case that Your Excellency depended on. In that scenario, the ethnic group was being targeted for the reason of belonging to that ethnic group. In the present scenario, there is even the statements that Birani problem must be resolved does not provide the sufficient evidence that the issue must be resolved for the reason of being Birani. Rather, it is because the regions from which the attacks arose from were a Birani majority area. That is why, because of the fact that Mara was a population of 70% Birani, because of the fact the ministry directive used the language that it is a Birani problem that needs to be solved. Not because of the fact that they are Birani, but rather because of the fact that it is the Birani region from where these attacks are emerging from. If that is satisfied.
No, Councillor, it doesn't.
I'm going to add on to my colleague's question. Paragraph 57 of the agreed facts, the second sentence, it says if the separatist statement is rooted in their communities, then those communities must be broken entirely. We've seen a very similar sort of rhetoric in the case of Israel and Palestine, where some parties contend that it is genocide and others contend that it is not. Can you differentiate this from what's happening in Palestine? Where entire communities might be getting there might be genocide happening because Hamas might be embedded in those populations?
Your Excellencies, in the present case, there is evidence that, contrary to the case of Palestine and Israel, in this present case, there is evidence that civilian population, the civilian homes and infrastructure had armed weapons. It is a rule of customary international law and international humanitarian law that in such scenarios, this makes the infrastructure and civilian targets a military target. In this, since the irrelevant and military target is being achieved.
Is there evidence to suggest that arms are only held by those belonging to the Birani ethnicity? Because again, we're not right now, like we told the prosecution as well, we're not sitting as judges as to whether or not the state's conduct was legal or illegal. That's a separate question. We only want to see the state's motivation. What we see right now is that for the first time in your country's history, an ethnic group, a minority ethnic groups, occupies power by winning the parliamentary elections. Shortly after that, their leader dies. Their leader's autopsy is not conducted because of your state's intervention. Then we see that the parliament is dissolved, and as a result, even after the leader's death, other members of that political party are not allowed to assume power. And then we see right after that, there is a grand operation against individuals belonging to that ethnic group. So it's not just one fact. We see the entire totality of circumstances which suggest that there was some ill will from your state as well. So again, the question is not whether or not they had arms. The question is, was it only the Biranis who had arms?
Your Excellencies, the attacks that were launched by the military forces of the state of Ashkar were not targeted at Biranis keeping the arms. Rather, they were targeted exactly and precisely using weapons that were employed directly at places where the weapons were employed. Not for the reason of being Birani, but for the reason that these weapons were present and stored and hidden, in fact, under this infrastructure of Biranian population. Not for the reason of being Birani population, but it was just as a matter of fact that these the arising attacks and the hidden military sources happened to be within Birani infrastructure, which is later on found that it was by Birani people themselves. Your Excellency has a question?
I do. I want to understand. Firstly, we have to go back to find out if that was even sufficient, that explanation. But I think subsequent to what I would like you to address is the element of proportionality. The agreed statement of facts and the measures that have been taken, and I would like you to specifically address those measures and take us through how are those proportionate to the alleged scenario that you're trying to defend in the statement.
Certainly, Your Excellency. As regards the evidences that are present in the present case at hand, the attacks that were launched by the military force of the state of Ashkar were proportionate because of the fact that they were launched in organized groups and they were launched at military targets. In fact, if I may refer Your Excellency at paragraph 46. They were drones that were armed Birani snipers. Secondly, in paragraph 40, it is mentioned that the movement of Birani separatists, as well as civilian losses, if any, were the results of militants using human shields. Your Excellencies, although we acknowledge the fact that there is no exact statement which would draw Your Excellencies to come to the conclusion that this would be proportional. However, if we give attention to the statements collectively throughout the moot problem, it proves the fact that all the attacks that were launched by the armed forces were in response and were justified by the attacks that were in the means that were being
these are
employed.
really statements by your own government relying on their own intelligence reports. We know that paragraph 52 says that your intelligence reports were also later found to be defective. So for you to justify your entire actions, now we're essentially looking at your conduct. And your only justification is that, well, my reports say that I was justified. That's
Yes.
not really... Is there any independent corroboration that Biranis were predominantly involved in this violence? We understand there was violence. We understand that there was a legitimate need to quell that violence. There are two questions. One, was your response proportionate? And number two, was it only the Biranis who were perpetrating this unrest because you had essentially encroached upon the rights of your population by dissolving the parliament? The Birani-led party had support from across the country because Biranis are 22% of your population. Despite that, their party, the BLL, won a parliamentary majority. So our concern again and again is that there was a party which had support from people across the country, and yet while you claim to be operating against them, your actions predominantly hurt the Biranis only.
Your Excellency, as regards in response to Your Excellency's question of being of the actions of the military being proportionate in response to the arising attacks from the Birani themselves, we submit that because of the fact that Biranis were using human shields, because of the fact that Biranis were hiding them in hideouts, the military weapons.
Is there any evidence in the agreed statement of facts about them using human shields?
Your Excellencies, the fact that
Is there not? Is there
Paragraph
any
40
evidence? Please take us to that paragraph.
The paragraph 40 does state, Mr. Nizam.
4040?
Yes.
Yes, please.
It does state that civilian losses, if any, were the result of militants using human shields.
This again is a statement attributed to your government only. Again, no independent corroboration.
Your Excellency, the statement of facts do not stipulate any exact fact that would be an independent inquiry. However, in the present case, because relying on this facts that have been presented.
So you're right that the agreed statement of facts don't say there was some independent corroboration. Yet it says that your government refused to participate in any independent inquiry. It says Nizam dismissed independent inquiry, stating civilian losses, if any, were the result of militants using human shields. So this, if anything, suggests that your government refused to submit to any independent inquiry and merely claimed that, well, our violence is justified because we say so.
Your Excellency, in the present scenario, Mr. Nizam dismissed independent inquiries because of the context of the state. At the present scenario, they were terrorism acts that were inciting and arising from the Birani majority areas. To counter-surge these arguments, it was that these inquiries were dismissed, and not because there was a perpetration or an aim to eradicate Biranis. For the element of genocide, it is required that Biranis be eradicated for the reason of being Biranis. Even if there were casualties even if there were losses and attacks that were launched against the Biranis, they were not for the reason of being Biranis, but rather they were for a military necessity. In regards to Your Excellency's question of military necessity, it is proven in the case facts that there were arms which are hidden within civilian homes. There were also, it is in heightened protection under international law in cases where human shields are used, or in cases where armed weapons are hidden in civilian structures. These remove the protection of civilian structure and make these houses a relative and military target. Also, for the satisfaction of military target, it is required that the attacks launched must provide a military advantage to the attack by the perpetrator of those attacks. In the present scenario, because by launching these attacks against the terrorist activities that were arising from the regions of Mara, the state was able to restore peace in the region, and therefore it does satisfy the requirement of military advantage which was procured. If we're ex-
Counsel, I think if we look at the bigger picture, you're asking us to set a precedent for how warfare is conducted in highly densely populated urban areas. You mentioned that the target was not the Birani population by virtue of being Birani, but military actors that were causing unrest in the state. You also said that the state managed to achieve peace in the region of Mara. Can you explain why the government moved from using targeted military raids to wide area bombardments across rural Mara? What evidence did they have to kind of bring on that sort of destruction on a rural area? Why did they use wide area bombardments? And this is, I'm quoting from the statement of agreed facts. Why did they use napalm variant incendiary munitions, cluster munitions, and high yield demolition bombs? If the aim was not to target the Birani population as a whole, but only specific actors within the population, why were these weapons needed?
Your Excellencies, as regards the methods employed for the killing or for the destruction that occurred in the present case, for the crime of genocide, it is irrelevant for the number of killings that occurred or for the amount of damage. In fact, relying on paragraph 67 on the Al-Bashir case of ICC, it is stated that genocide requires not just killing, but rather destroying a substantial part of the population. In Al-Bashir, the ICC case, there was a murder of thousands of civilians. This has also been approved in subsequent judgments of the ICTY as well as the ICJ. Despite hundreds and thousands of killing and destruction, genocide was not established. This is because this does not fulfill the requirement of genocide because of belonging to that group. It is the specific intent, which is the mere factor that needed to be proven. In scenarios just like the similar case, it's not proven. Genocide, despite the large destruction, despite the fact that weapons were used which might have caused a substantial amount of destruction, although we do value the importance of human life, as for the purpose of genocide, it does not fulfill the requirement. I see that my time has lapsed. If I may conclude my arguments.
What I see is a lot of statements and going back to the same assertion, which is that it is not a particular group that we're targeting, but it's by virtue of what's happening. But what we do not see is a correlation between the measures that were undertaken and, coming back to your explanation of as to what warranted those measures, right? So that's something that is still, I'd say that, if you have something specific to address in that regard, you bring that up. The other thing is that how do you justify, or what would your response be to the fact that all of this was happening and no redressal measures were being?
Your Excellency, in response to your first and second question, we shall be submitting that this pertains to the second part of my submission. That is, Mr. Nizam did take necessary and reasonable measures in the present case. Drawing reference from the ICTR case of Kayishma, which I'd like to submit to the court.
First, because you're saying that you took those measures, so first, please tell us what those measures were, and then we can look at the cases that you cite.
Your Excellency, as per the requirement of taking measures, they need to be reasonable and necessary. If Your Excellencies may read paragraph 511, it is not required to do the impossible. In the present scenario, there is a margin of precision that must be required. Because there is a context of instability and destruction in the region of the state of Ashkar, it cannot be considered it cannot be deemed necessary or responsible for Prime Minister Mohammad Nizam to argue or to intervene between the military objectives that were aimed at the terrorist attacks. Prime Minister Nizam did not take the measures to stop the. We do acknowledge the fact that Prime Minister Nizam did not take measures against it.
Did you not just say that he took those measures a few sentences ago? I mean, what we expect is that we understand that there might be certain issues, certain security considerations as well, but we'd expect you to take a consistent position at the very least. So 3 sentences ago, your position was that we took those measures, and in the facts and circumstances of this case, those measures were adequate because we could not have done more. And we perhaps may agree or may disagree with that. But now your position is that we could not have taken any measures?
Your Excellency, to clarify, my position is that Mohammad Nizam took all reasonable measures, which do not...
Let's stop here now. What were those reasonable measures?
allowing the military forces and the ANA commanders to launch the attacks?
No, we're not asking if he did all he could to eliminate the population. We're asking what did he do to protect the population, not eliminate it. So again, can you list down 3 things that he did to protect the population?
Your Excellency, the facts do not contain any evidence
So
of
there is
Mr.
no
Nizam.
evidence to suggest that he took any measures to protect the population.
Your Excellency, Mr. Nizam did not take any measures to protect the Birani population. This is not because he had the intention or the aim or objective of committing genocide, but rather because it was not within his effective control or responsibility as the Prime Minister of the state. This was the responsibility of the ANA forces to conduct military operations against
Who do the ANF forces report to?
the ANA commanders.
And who does the commander report to?
Your Excellency, in the
Who
present...
has the right to appoint the commanders, remove them from service? Who was the head of the state?
Your Excellency, Prime Minister Nizam was the acting Prime Minister. There is no evidence in the statement of facts where Prime Minister Nizam directed or actually perpetrated those attacks.
So what we understand that. So in any case where there's a civilian leader and he's accused of genocide, he does not actively go and shoot at citizens. But the idea is that the forces report to that civilian leader.
Yes.
Now, is there any evidence to suggest that they did not report to him or that your Prime Minister issued direction which was then flouted? Is there any evidence to suggest that?
Your Excellency, in response to that, we submit that the Prime Minister Nizam was not informed and had no knowledge of the commission of genocide or the killing of civilians in the present case.
He was saying that, yes, we are killing civilians, but we're doing that because they are using others as human shields. So that means he was not really ill-informed, was he? Again, now, let's take a step back. Is your position that, yes, there was genocide, but it is not attributable to the Prime Minister because he was not informed about the facts on the ground? Or is your position that, well, there was no genocide? Because it appears that your position is rather inconsistent. You're saying that while all these things were happening, but we were not informed. Is that your position? Or is your position that these things did not happen at all?
The latter, Your Excellency. The acts constituting genocide did not happen because the elements of genocidal intent, which is the crucial element and perhaps the mere factor of which was directed in the drafting of the Rome Statute, that is absent. With no intention, there is no, despite the large number of killings, which we do accept and acknowledge, even then the genocidal commission cannot be established, and therefore we also submit as an alternative argument that Mr. Nizam is not responsible for it because he did not also have the knowledge of the casualties that were. He was present. He was aware of the casualties that were occurring, in response to which he said the statement that Your Excellency quoted. However, he was not aware of Biranis being targeted for the reason of genocide. He was not aware of civilian population being targeted. He's used the word of human shields since that is what he was informed. That is what the military targets were informing, since in all the directives as well as the ministerial armed forces targeting were.
Counsel, if we take a step back from this case,
Yes,
forget
Your
this
Excellency.
case, because any order judgment that we render will have effects on subsequent cases that we hear as well. Would this not be an issue in any case today if you were to try Israel's Prime Minister for genocide, if we come to a conclusion that what's happening in Palestine is a genocide? Would not every head of the state say that I was not informed about what my military was doing? Because no head of the state goes to the battlefield himself. He does not shoot at civilians. He does not drop bomb at civilians. So would that not be an issue in any case? Would the definition that you want us to lay down, would that not preclude us from holding any civilian leader accountable for genocide?
Your Excellency, we would like to distinguish that the present case from the Israel case. In the Israel,
No, any case. I was
Yeah, or
giving that
any-
by way of an example. My concern is that if today we say that, well, there was genocide, but the Prime Minister did not know about this, and as a result, we'll absolve him, would that definition not be used by every civilian leader saying that, well, there may or may not be genocide in my state, but I was not the one who was shooting at the citizens?
Yes, Your Excellency. In fact, we would not suggest that this should be established. In the present case, our position is that Muhammad Nizam was not aware because all the official documents stated that Biranis were being targeted because of militants. They were being targeted because of weapons being stored in homes. They were being targeted because of suspected hideouts.
Circumstances should we hold that a civilian leader is or is not informed about what's happening in the state? Because there will have to be a legal standard that we set. So in what circumstances, and I'm not talking about this case, in any case, what is the legal standard that we should set that in these circumstances, a civilian leader ought to be absolved on the basis of him not having handled.
Your Excellency, this threshold has already been established, has already been set out in the judgment of Prosecutor versus Orich in paragraph 319, where it was specifically mentioned that knowledge of the superior cannot be presumed, but rather it is, even if the acts were, the details and awareness is not. The threshold for the intent of genocide, Your Excellency, as set out by International Court, is extremely high, which is why it has not been set, it has not been established as yet in previous cases as well. Therefore, in the present case, we also submit that because of the lack of knowledge of Prime Minister Nizam, as well as coupled with the fact that Prime Minister Nizam was an acting Prime Minister. Yes, Your Excellency. Page number. Your Excellency, page. It's paragraph 319. In the absence of direct evidence, however, actual knowledge may still be established by way of circumstantial evidence. Yes, Your Excellency, in the present case, precisely, Your Excellency, it is our position that in the present case, it cannot be inferred from the circumstances at hand, because the attacks were launched not at civilians directly. They were launched at military targets, which we have established were qualified military targets under international law and had heightened protection. Therefore, it is our position that the circumstantial evidence is, and there is no circumstantial or direct evidence in the present case. The military forces that were reporting to Muhammad Nizam had been stipulating in all of their directives that it was the military Biranis that were being targeted. It was at the tunnel from which Birani populations were rising from that were being targeted. It is nowhere mentioned in the statement of facts that Biranis, for the reason of being Biranis or civilians, are being targeted. Therefore, it is not possible for deduction to be made that Biranis were being targeted. Your Excellency, there is no exact mention in the statement of facts for the criteria mentioned. However, in every attack that was launched, it does provide a statement that was given by the military commanders of either civilian homes having armed weapons or Birani militants hiding in areas, all of which do constitute a high threshold of military target. If that satisfies Your Excellency's question, this does conclude my arguments pertaining to count 1 regarding the commission of genocide, as well as Muhammad Nizam as the Prime Minister not being responsible for the commission of genocide. It was a pleasure pleading before this court. Thank you.
May it please the court. My name is Ayan Khan, and I would be assisting the court. Ayan Khan, yes. I appear before this honorable bench representing the defense, and I would be assisting the court on the matter of count 2 and count 3. Honorable judges, before I begin with my submission, I would note that the prosecution has not fully established the count 3 of murder by not conclusively establishing contextual elements for it, and other than that, the mens rea for prosecution relied on was merely a leaked ministerial evidence, to which I would also address in my submission. Furthermore, honorable judges, the prosecution has misinterpreted the facts or not presenting them in the correct way, as they have considered that the use of napalm weapon is considered illegal by Akshar themselves. It is not mentioned in the facts. Furthermore, they have considered that wells were poisoned. It is also not mentioned in the facts. I will start with my submission that forcible transfer under Article 71D and murder under Article 71A of the Rome Statute uh, the contextual elements have to be first proven for both of them, and thus I shall argue them collectively. Firstly, honorable judges, we note that no widespread or systematic attack was directed against the civilian population, as is mentioned in Katanga trial judgment, that the
Counselor, I think it'll be more helpful for you to first lay down the elements that they had to satisfy, and then perhaps you can move towards highlighting how they have not satisfied those elements. Now, they had highlighted for your convenience 5 elements: actus reus, there has to be a lawful purpose, that they're lawfully present in that area, the civilians, that the state does not have any grounds permissible under international law, that it was widespread, and that there was mens rea in your case. Now, based on these 5 elements, if you could now show this court what elements were missing in the present case.
honorable judges, I would mention that the structure of the prosecution is inconsistent with the law, as firstly the contextual elements have to be proven, second the specific
Counsel, again, this is
Yes.
an
Honorable
advice you've been giving everybody across, that listen to the question and then answer the question. They had said that there are 5 elements that they had to show to suggest or to establish that there was forcible displacement of the population, right? There are 5 elements. Which of those 5 elements do you think are not fulfilled in this case? Now,
honorable judges, there are 3 contextual elements in Article 7, which is widespread or systematic directed against the civilian population. The second element, that the perpetrator had the knowledge, and third is that no action had been taken. Right? We know
do you
that
not rely on the defense that
State
you
or
could have displaced the population if you had the grounds permissible under international law, because even the prosecution acknowledged that there might be forcible displacement of a population, of a civilian population, if a state relies on the grounds permissible under international law.
yes.
They were arguing that those grounds were not fulfilled in this case. But is that not a defense that you will rely on?
I am relying on that.
Now, what are those grounds under which you, as a state, may displace a population, and how were those grounds met in this case?
Honorable judges, we note that this point is pertaining to specific elements of the forcible transfer, not the contextual elements, and it is that transfer within the exception of international law. We rely on Article 49 of the 4th Geneva Convention, which allows total or partial evacuation of the population if the security of the population or imperative military reasons so demand. Honorable judges, we note that ANA launched proactive voluntary evacuations to minimize casualty. It was not a chance of course or expulsion. It was a voluntary act. It was in compliance with, as so far as possible, with the Geneva Convention. The civilians were taken to safety camps with the protection of the Akshar army. They were provided with ration foods, and they were secured from the Birani militants themselves by secondary screening. If we also rely on that, there was no expulsion or coercive act. This is another specific element of forcible transfer, which is also not proven.
Counsel,
Yes.
can you read the last sentence of second paragraph of Article 49?
Second last.
So second paragraph,
Second paragraph.
look at the last sentence.
Persons thus evacuated shall be transferred back to their homes as soon as hostilities in the area in question have ceased.
Okay, and can you reconcile this with the fact that 320 Birani villages were partly or fully destroyed?
Yes, honorable judges.
And so did those people have a home to go back to?
No, honorable judges. The fact that the Geneva Convention states that the civilians which were transferred in demand of the security or military reasons shall be sent back to their homes once the hostilities have ceased. In our case, the hostilities were ceased. However, the homes of the civilians were the object of military attack in the first place, to which they had to attack it by using bombs, after which there were no homes to live left for them to go. However, the place where the civilians were residing, civilians are not forced to be at the safety camps, and the facts are silent on the further evacuation procedure stated by the government.
Counsel, I
if you
feel
could-
like you're making a few concessions here. If I'm not wrong, I heard you say that you did attack civilian homes and those were a part of your military campaign.
No.
How did you differentiate between civilian homes and military hideouts?
Especially if those people had left their homes already, so they were obviously not active military targets since they had left their homes. So for you to be destroying entire villages, homes of people who were not active military targets also raises a question. If also while you answer the question raised by my colleague, you could also address us as to how the requirements laid down in paragraph 3 of Article 49 are met. The occupying power undertakes such transfers or evacuations shall ensure, to the greatest practicable extent, that proper accommodation is provided to receive the protected persons, that the removals are effected in satisfactory conditions of hygiene, health, safety, and nutrition, and that members of the family are not separated. Now, if you read these requirements, can you try to reconcile these with paragraph 55? Now, perhaps read this, and now, if you could, for our convenience, read out paragraph 55 of the agreed facts.
Honorable Judges, Your Excellencies, it is stated in paragraph 55.
Just read that out for our convenience.
Read out.
Paragraph 55 of the agreed statement of facts. If you could read it out for our convenience.
The whole paragraph.
Start from in practice, however.
In practice, however, these measures constituted forced displacement of Birani communities across northern and central Mara. Military units delivered evacuation orders and gave residents between 30 and 2 hours to leave their homes, often during early mornings and hours when movement was difficult. Houses were marked with red paint to indicate security risk residencies, and ANA soldiers routinely threatened residents with detention under Security Deterrence Act if they refused to comply. By late March 2024, approximately 180 Biranis had been pushed outward towards the lowland plains, where makeshift camps were established under strict military supervision. Reports from humanitarian observers documented that the camp entry required fingerprints, family rosters, and declarations of political neutrality.
Let's stop here, Council. Under what law, under what justification did you expect the population that was displaced to be politically neutral? Could they not have political views?
Honorable Judges, political views were the cause of action of
No.
all of the
The
insurgents.
cause of action was them taking the law into their hands. They may be supporters of a political party and yet be peace-loving. Unless you say that anybody who supports a political party was active military target and was a legitimate military target. Is that the argument that you canvassed before us?
That is not the argument.
Then why were they supposed to be politically neutral? Or they could be supporters of a party other than BLL as well. They could be supporters of any political party. They could be supporters of any dispensation. Why were they expected to be politically neutral?
Honorable Judges, politically neutral, we have to understand why the ANA required the citizens to be politically neutral. Is
there any law which justifies a state impressing on citizens the need to be politically neutral?
I'm not aware of the law.
Any judgment, any order which says that, well, if there is an active hostility, the state can demand its citizens to be politically neutral.
May I confer with the researcher and get back on the question later?
Yes, you may. Now, again, read the next paragraph.
From the start?
No, just the last sentence of this paragraph, 55. The next sentence of the same paragraph.
55. Okay.
Yes.
Residents were routinely interrogated, with many men separated from families for secondary screening, after which thousands disappeared without official acknowledgement.
Now, we see that Article 49 says that when under compelling circumstances, whether or not there were compelling circumstances is also a question that we need to determine. But under those compelling circumstances, you ask people to display political neutrality, which according to you right now, you don't have any justification for it under the law. You're looking for that justification, but for now you don't. Then those people were forcibly disappeared without any official acknowledgement, whereas Article 49 says that individuals who were taken outside their areas must not be removed from their families. How do you justify that?
Honorable Judges, the secondary screening that men were supposed to take was to ensure that there are no militants in the
Yes,
camp
but
themselves.
then why would you not officially acknowledge that? You should have officially acknowledged that, presented them in a court of law, attempted to convict them. Does the fact that they were military targets or the fact that they were militants, does that mean that they were not entitled to any rights? Does that mean that you can forcibly displace somebody just because you think that they were militants?
Honorable Judges, enforced.
Should we allow any state to forcibly displace anybody who the state thinks is a militant? Is that permissible under any convention of international law?
Yes, the state is.
Which one? You said yes. Which convention? Which convention, which judgment, which law allows you to forcibly displace a person who you think or your state believes is a militant?
Honorable Judges, the militants are.
Council, you said, we said, is there any convention? You said yes.
Convention.
Just name any convention, any law, any principle of customary international law, any judgment which says that you may forcibly displace somebody just because you think they are a militant. One. Just one. Because you said there is. So, any convention, any law.
Judges, what I mean to consider is that the militants.
Law. We'll consider your arguments. But answer our question first and then we'll hear you out. We want
I'm
our
not
questions
aware
to be
of a
answered.
specific law.
So right now, you said there is no law, according to your information,
There is no.
which allows you to ask your citizens to display political neutrality. You say that you don't currently have any law which justifies forcible displacement of citizens who were confined to these camps, and yet you say that this court should allow you to displace citizens just because you rely on Article 49, because Article 49 itself does not really come to your aid. Article 49, firstly, can only be invoked in compelling circumstances. Then once you invoke it, Article 49 really confines or really lays down very strict standards that the state has to follow. So right now, under Article 49, how do you justify your conduct on the touchstone of Article 49?
Honorable Judges, it is mentioned that the defense does not merely rely on Article 49. We rely that to be charged under Article 7(1)(d) of the Rome Statute, the contextual elements and the superior responsibility under Article 28(b) also has to be fulfilled. So thereby, we know that neither the contextual elements are fulfilled nor the specific elements, neither the Article 28(b).
So you haven't until now given us any justification for the displacement.
Honorable Judges,
You're saying that there were other factors that you met. Which other factors were not met over here? There are 5 elements that we've laid down. What other elements, to your mind, were not fulfilled by the prosecution?
Honorable Judges, the defense would like to argue the contextual elements in the light of the count of murder and enforced displacement concurrently. May I start that there was no attack directed against the civilian population. Honorable Judges, as the judgment of Katanga trial is given, it notes that an attack shall be direct, the civilian population shall be the primary target and not incidental victims. In our case, Honorable Judges, it is consistently mentioned that non-state militants, armed Birani separatists, militant operatives, training camps, Hassan Align regrouping, all of such militants were targeted.
How do you define non-state militants? How do you define non-state militants in this case?
Non-state militants are the population of Biranis or the BLL supporters. When incited, they took law into their own hands.
I'm not asking you factually. I'm saying legally, how do you define non-state militant actors or non-state militants? How do you define them? Because otherwise, any state could come to us and say that, well, yes, we acted against, we eliminated an entire ethnicity, but while they were not civilians, they were actually non-state militants. So how do we draw that distinction?
Because to draw that distinction, we know that we can provide an article which states the difference between civilians and non-state militants.
Can you please invite our attention to such article? Because articles may also be a source of law under the Vienna Convention, right?
Exactly.
So can we have a look at that article?
My researcher will provide, and I would request a copy for myself as well.
Yes. So we can now, once you have a copy, once you peruse it, please answer our question, because we want to know how do we distinguish the two, civilian population and non-state militant actors.
Certain.
So why we can part this issue?
While you wait for
Yeah.
the answer, you can address it.
Certain. Honorable judges, we know that non-state militants are the ones who break the law and target and terrorist attacks which occurred, 3 terrorist attacks occurred by armed Birani specialists which resulted in death of 140 military personnel and 10 civilians. We note that the remaining civilians, 2.1 population of Marra, were civilians, but the ones involved in the 3 terrorist attacks would be non-state militants. Does that suffice the question?
Yes. Let's move on.
Honorable judges, in the present case, we know that all of the operations were directed against the non-state militant cells and not at civilians. Thereby, the first contextual ground is not established, due to which count 2 and count 3 both fail. We further note,
Can you elaborate on that a little bit?
honorable judges, we note that the contextual elements are needed to prove any count under Article 7.1d or 7.1a. And as the attack was not directed against civilians in the first place, the contextual elements are not proven and therefore both of the counts fail. For further assistance of the court, we would note down other points as well which are not met. However, if this point is established and accepted by this honorable bench, then the charges would not be confirmed under Mohammad Nizam.
We've noted that, but we'd like you to expand on the other.
Judges, we know that Mohammad Nizam had no knowledge of the conduct being part of the attack.
So
The
how
requi-
do you address paragraph 59?
Paragraph
59 of the agreed facts, statement of facts.
59.
Our units report significant civilian casualties.
Honorable judges, the defense submits that the leaked ministerial directive as well as the margin note given to the Prime Minister's office.
Yeah.
We note that under Article 69.4 of the Rome Statute, on that premise, the margin note and the leaked ministerial directive are unreliable. Thus, relying on this evidence would cast serious doubts on the integrity of this proceeding and would be prejudice to the trial of the accused, as it cannot be cross-examined or verified by whom the leaked ministerial directive was given or by whom the margin note was written, and does not conclusively establish that Mohammad Nizam was involved in this or it is associated with him. Therefore, we also note that the contextual elements are not met. Honorable judges, my time has lapsed. May I have 3 minutes to conclude my argument or
Yes.
complete my argument? Honorable judges, we note that we explained to the Honorable Court that the transfer was within the exception of international law, Article 49, although the civilians were not being able to go back to their homes because of destruction. However, we also note that the specific element that there shall be expulsion or coercive acts. We note that the judgment of Kenya, we note that coercion was set in, it stated that for physical violence was against the civilians, the burning of their homes and destruction of their property, sexual violence to forcibly evict women and their families. And this resulted in people leaving their homes in panic under emergency conditions. We note that in the present case, there was no coercion by the ANA or harm to civilians, physical or in any other way. Honorable judges,
Counsel, go to paragraph 58 of the agreed facts.
paragraph
58,
58, yes.
It says here, civilians who refuse relocation are to be marked as hostile. How does that align with the precedent you've put before us? How is that not forceful evacuation? Because if they aren't leaving their homes, they're being marked as hostile. Their homes are being marked as high-risk targets.
Honorable
How
judges,
is that not a forceful evacuation or eviction?
Honorable judges, the force or the needing for the civilians to evacuate came from the law, the statute. The statute, according to the statute of Akshar, the civilians had to move from the place which was object of the attack of the military. And when ANA had to attack in a specific place and the civilians who refused to move, it is clear that it was in support of the militants themselves, as it is proven in the facts that weapon stockpiles and militant training camps were hidden in civilian settlements. So there is no reason for a civilian to break the law and not move due to the command of the military. Thereby, there were no coercive acts. They were not forced or beaten to get out of the homes. They were simply marked hostile for the ANA to know that whether they are supporting the militants or not.
I, and perhaps my colleagues will agree with me, I find it suspicious that you stopped short of physical beating and coercion and used that threshold to claim that you did not forcefully evict these people from their homes. There is also the fact we have before us of more than 15,000 deaths happening in Marra, and your state calling it a fully pacified event after those civilian deaths have occurred. What we're seeing before us based on the facts is you creating such a hostile situation that people have nowhere to go unless they follow your directives. If that doesn't amount to forceful eviction, I'm not sure what else does.
Honorable Judges, we provided the Kenya judgment to refer what forceful coercion or forcible transfer is. And in the state of emergency where the ANA had to target to remove militants which were deploying terrorist attacks, that was a situation where the ANA would want the civilians to step aside due to, as it is already noted, that high casualty had occurred in Marra. And when the ANA tried to protect the civilians, to take them to protection camps, the charge of forcible transfer had occurred by the prosecution. We note that the charges of murder and forcible transfer are contradictory in nature in the present case. As if murder, it is argued that civilian threshold is high, and when the civilians are taken into protection zones to be away from the C4 explosions, it is said that it is forcible transfer. We know that there is none of the crimes occurring in this present case.
Counsel, you can move on to wrap up your arguments. I'm not satisfied with the answer for this, but I understand that you're on a time limit.
Honorable Judges, we note that conclusively that till Mohammad Nizam is not responsible under Article 28B, that the superior responsibility is not established. Honorable Judges, we note that as my co-counsel mentioned in Orage, the actual knowledge requires the superior to know that his subordinates were about to commit or have committed relevant crimes, and it cannot be presumed. The defense had already established that civilians were not the primary object of the attack. Thereby, he could not have consciously disregarded such information. Furthermore, we note that the conduct within Prime Minister Nizam's control. Honorable Judges, we know that the conduct was not within his control and therefore he could not punish it as well. As according to Cordage, paragraph 405, there must have been an ability to punish for effective control to be established in the first place. We know that Prime Minister Nizam only had the responsibility as Prime Minister under Article 64 of the Constitution of Akshar, and it is silent factually on the grounds of power granted to Prime Minister Nizam. We note that we cannot imply any de jure or de facto powers as it is stated in Bemba, mentioned in Memorial, page number 17, footnote 66. Honorable Your Excellencies, we note that even in global practice, such as if we consider the case of Pakistan as well, Prime Minister has no authority to punish the military objectives or to direct them in such a manner. He has the powers over the government. The military is, the authority over military is given to the President themselves or the Chief of Army. And Prime Minister has no say in this. Thereby, we establish that Prime Minister Nizam is not, superior responsibility is not established under Article 28. The defense, in light of the facts mentioned and authorities argued, we pray that this Honorable Court may be pleased to find and declare and adjudicate that there are no grounds to believe that Mohammad Nizam committed the crime of enforced displacement under Article 71B or murder under Article 71A and is not responsible superiorly under Article 28B. It was an honor to plead before this court. Thank you so much for that.
Oh, okay. It's like, wow. Okay. So I think you guys, congratulations for coming thus far. We could see that obviously there's a lot of hard work gone into this. So congratulations to both the teams for that. I would think that there are 3 points that you should make a note of moving forward, right? When you come, there's a whole hard work and prep that goes into preparing a case and making your arguments. And then when you come to the podium, you come with a certain script in your mind, right? That this is how we're going to intro, this is going to be this, and this is how we'll conclude. But when you do get to the podium, naturally the judges can completely throw you off. And I think that's one of the things that, we would really like for you as litigators to be prepared for. When you come on the podium, you do not know what the judge is sitting there with. Is he one that will let you complete your thought, your case, and then wait for counter questions? Or is it a judge who's just going to be with you from the beginning? So that's one thing, right? When you're coming to the podium, make sure that you don't have a fixed criteria and you understand your case more than the pleadings, and you understand what the context of that case is, so that whatever the bench is questioning you, you can answer it and you can meet the bench right where they are, okay? That's number one. Number two is, it is fine to not know. It is absolutely fine to not know. When we get into litigation, we feel the pressure to know everything. There are a lot of laws under the sun that one cannot know, and it is okay to say that I will take time and I will revert to you on it. You park the issue and you move on. So when you step into this field, it is absolutely okay to be like, my lord or my lady, I will get back to you on this, allow me some time. Meanwhile, we'll move on to the other issue. So that's number two. Number three is, you should really listen to the question that is being asked, and it's okay to get clarity from the bench, right? Get clarity. If you do not understand the question, ask for more clarity so that you can answer constructively, and really understand the question first. Sometimes we feel like a question may require a lot of wisdom. Sometimes it's really something very basic. These are the 3 points from me, and I'll let Moise take it on from here.
Like Anya said, I also felt that all the teams were really well prepared. So congratulations for coming up to this point in this competition, and we will have to do the teams with forward. I think individually, I like how the appellant's first speaker was addressing questions. And I think that's the expectation from all of us, that when we get a difficult question, don't try to flirt around with the question. Address the question first, and then you can say, well, but yes, I acknowledge that this is a weakness in my case, but here is my defense. Because we understand that in a moot problem, the organizers of this competition have deliberately designed the problem in a way where each side has certain weaknesses. So you might in real life have a case which is completely clear. In a moot court competition, you will never have a clear case that's completely clear. There will invariably be weaknesses in your case. So it's okay for your case to have certain weaknesses and for you to not have an answer to certain questions, but don't try to find your way around those questions. Address the question. So that's one piece of advice. With the appellants, I felt that there were some things that you could use from the facts that were not exploited. So, for example, when you were addressing the Prime Minister's liability, if I were in your position, I would have addressed the fact that this Prime Minister contested the elections on a nationalistic rhetoric. And at that time as well, he was saying that, well, provincial disunity must be avoided. So he had a preconceived notion against this ethnicity. And when he came to power, he was acting on that preconceived notion. So I just think that the use of fact could be slightly better. With the appellant's second speaker as well, I felt that you could brush up on the facts and the law as well. Because I felt with certain questions, the answers could have been better. The answers could have been more direct. One thing that I felt was too excessive from both the teams was the note exchanging. Because I felt that there was a point when your second speaker was about to conclude, and when the bench is asking too many questions, the bench is also seeing how you operate under pressure. So there's one pressure where you have to address the bench's questions, then there's somebody in your ear giving you notes. So I think that only complicates things more. So once she is there, once you have a team member who's there, trust them to address the bench's questions. If you think that maybe my intervention would help them do that, but don't do that excessively. And that's something I also noticed from the respondent side. So that's something that I think can be avoided going forward. With the respondents, I really liked how you addressed the court. I think in terms of style and poise, you were really well. I think what was really good about your submissions was that when you came, you gave us a roadmap that these are the two submissions I will address. For the first submission, ABC. For the second submission, ABC. I just felt that the use of law could be better. I think, again, and I think with you particularly, because you guys, I think, had a more difficult case to argue. There was not much you guys had from the facts. So from that, I think you had to address the law. When we asked you, okay, what standard should we set? I think the answer should have been, well, this is how the court dealt with this issue in this case. Applying this to these facts, this is the standard that I think we should set. The other thing, as lawyers, I think the one skill that is indispensable is critical thinking. So when we asked you that what in your mind should be a standard that we should set as a court, we're looking at how well you were able to think on your feet. Because we're not asking you what a judgment says. We're not asking you to say what the facts say, because anybody can do that. Anybody can look at the facts, can maybe read up a few judgments. You don't have to be a lawyer for that. As a lawyer, critical thinking skills are what will distinguish good lawyers from bad ones. So that is perhaps a skill that you will have to develop going forward. But having said that, I think both the teams were really good, and I look forward to seeing you guys in other moots as well. Okay.
I'll just make some concluding remarks because I think both my colleagues have given great advice. I think anytime you walk into a moot court competition, you never know whether the panel in front of you will be a cold bench or a very active bench. And I think we had a really active bench there. Sometimes as an appellant or respondent, you walk in with like a speech in your mind. You know that you have an allocated time of 8 minutes per person, or sometimes it's even less, because I know that Jessup maybe has stricter time limits. And not too long ago, it was me on the podium instead of being on this side of the bench. So some advice that I've received in the past that I feel helped me in moot court competitions. First things first, know the facts like the back of your hand, and not just the facts that favor you, but also the facts that favor the opposing side. You need to be able to, like Moez said, like Hania said, think critically on your feet and be able to use facts against each other as well as in favor of your own team. And once you're able to do that, once you're so confident in your facts, then you need to remember that when you stand on that podium, you're not here to like give us a speech. You're here to have a conversation with us. And this will happen to you at any moot court competition, whether it's domestic or international, or whether you practice law in high court or lower court. It's a conversation with the judge, and that's how you should approach it. So when I ask you a question, or if Moez asks you a question, we should see the sort of attitude which says, thank you for asking me this. I've worked so hard and I've prepared so well. I'm glad you asked me. And this is the law, in fact, that I can use to like support my argument before you right now. Once we see that in your body language, in your style, in your poise, that automatically puts you at an edge. Like, of course, the substance of your argument also matters, but the way you conduct yourselves, the way you show me that you're excited and happy to be here, and you have prepared so well that you'll take any question that we throw at you, that's something that really sets you apart. And on the whole, I think both of your teams were so well prepared and you've come so far in the competition, so you do have a lot to be proud of as well. I would suggest for both of you to be sharper at answering questions and be a bit more direct. So if Moez or Hania, for example, ask you what is the convention you're relying on to support this argument you've made, don't give us a roundabout answer. Don't say that, oh, according to paragraph 55 of the agreed facts, that this is what happened. Don't do that. In a real life scenario, that will really annoy a judge in a high court as well. So just learn how to be more direct. And the last remark, don't make concessions when you're under pressure. Because that's something that judges will do, especially in a moot court context. We will drill into your argument and try to just find weak points and push buttons on you that will cause you stress. It's so natural to feel less stress. But once you have an argument, once you know what the facts are, don't buckle, don't backtrack. If you know what your argument is, don't change it just to make us happy. Like, stay like firm on what your argument is. Overall, I think you guys did pretty well. There's always room for improvement in everything we do in life, but best of luck for